Hi everybody, this is Mark Webster from vSure, and today we'll be looking at an overview of the Employer Sanctions Legislation. The Employer Sanctions Legislation came into effect on the 1st of June 2013, and it really does raise the bar for employers when it comes to illegal workers. It's much more powerful than the previous legislation that was in effect, and it makes it easier for the Department of Immigration to issue penalties to employers who have workers working in breach of visa conditions or without visas. And just to go through the main points for this legislation, employers now need to check work rights both before and during employment of staff. If you're just checking before engaging staff, that's no longer enough. You'll need to be checking during the person's employment as well to be compliant with the new legislation. An employer may now be liable for contractors and temps, even if they're not direct employees. Previously, the legislation only applied to direct employees, but now it applies to any arrangement or series of arrangements for work done for the business. For recruiters, they need to be aware that any potential staff or candidates that they're referring need to be checked for visa work rights before they're referred. Otherwise, penalties may apply if that person that's been referred does not have work rights. Previously, the Department of Immigration needed to show that there was knowledge or intention or negligence on the part of employers when they're hiring staff. This is no longer the case. A strict liability regime applies, and this means that employers may face fines even if they don't know that the person was unable to work legally in Australia. So when somebody is detected working unlawfully, significant penalties can apply. And there's a range of different penalties that can be imposed by the Department of Immigration, anywhere from a warning notice through to fines of $315,000 or more, and even terms of imprisonment up to 5 years. Another point that's very important to note for company directors and officers, they can be personally liable if they know or are negligent as to whether their staff have appropriate work rights. So certainly responsibility for this goes all the way to the top. Just quickly introducing vSure and how we can assist businesses to meet these new compliance requirements. vSure is an all-in-one immigration compliance package for businesses. It's easy to get your staff on the system, very easy to do visa checks. You can check your entire workforce with a single click, and it gives you more information about work conditions and visa types. It makes it really easy to track expiry dates of visas. In fact, you can set up a system to send you reminders via SMS, email, or calendar invitations. And that means you'll never miss an expiry date again. You can also set up automated checks that will go through all of your staff and check that the visa is in place. It could be every fortnight, every month, or every quarter. And that means that any changes or problems you'll get notice of so that you can take the appropriate action. It's also a multi-user cloud-based solution. So that means that if you have a lot of offices around the country, we can manage those individually, but you can still have oversight centrally that all the workers are being checked and make sure that all the various branches are doing the right thing by checking all the staff. So if you'd like more information about how vSure works and how we can help your business, please contact us for a demo. You can see our contact details there, and we'd be happy to talk about how vSure can help your business. Thanks everyone, and look forward to hearing from you. Bye.